Hello friends, welcome back to the series of lecture. This is the sixth lecture of this series of Indian Constitution. Now the next case is M. Nagraj versus Union of India. M. Nagraj versus Union of India 2006 Supreme Court. There are 2-3 points in this case. So write down the first point. This is also discussed earlier also. That is the substantive and procedural limitations. This we have discussed at the time of discussing case of non-Bharati case. So write down. The concept of basic structure provides for the substantive limitation upon the amending power of Parliament, whereas Article 368 Clause 2 provide for the procedural limitation. And the second point, broadly in the beginning we have discussed, when we have discussed the constitutional identity and constitutional supremacy. Actually in this case they were interpreting Article 16(4)(a) and B, and they are basically interpreting the concept of basic structure as given in the case of non-Bharati, and obviously this is the smaller bench of that case of non-Bharati bench. So this cannot qualify, this cannot add things, this bench. So it can only interpret what the Supreme Court had said in the larger bench, that is in the case of non-Bharati case. So इस केस में हम case of non-Bharati case को ही और clarify कर रहे हैं by making it more manifest. Second point में they are talking about basically about the constitutional supremacy and constitutionalism, and that already we have seen. इसमें भी आप एक point लिख लो इसके. The court held that the concept of basic structure is about the idea of constitutionalism, that is the idea of constitutional identity and constitutional supremacy. There are certain basic principles and values upon which the Constitution has been made, and these principles are inviolable and indispensable. That is, in no circumstances can these principles be violated, not even through a constitutional amendment. Now the third point is upon overarching principle. So इसको पढ़ने से पहले first of all you must to know that what are the overarching principles. So what is arch? Arch is something which covers something like this. These are two things and it is arch and it is covering it. Overarching is what? Something which is covering it. And the word used overarching is used for the basic structure. And you know that basic structure is about certain principles. जो आपने अभी second point में पढ़ा है, that basic structure is about certain principles. Which principle you can say that cut across the entire constitution and every article and every provisions of the constitution. These principles have to be the governing principles, and in no circumstances these principles, be it explicitly written or be it implicit, in no circumstances these principles can be taken away. So these principles are certain principles which shadow the entire constitution, or which covers the entire constitution, or you can say which are the undercurrent to the entire constitution. जैसे हम natural justice की बात करें, ये कुछ सिद्धांत हैं. जैसे natural justice, you cannot find alone natural justice in one article only. This is the principle which is found everywhere into the constitution. So basic structure को explain करने में Supreme Court ने कहा, देखिए basic structure is nothing, it is a set of principles which are overarching in nature, which cut across all the provisions of the constitutions. They will not be expressly written, but you will find them everywhere written. अब जैसे natural justice article 14 में भी natural justice है, 15, 16, 19, 21 everywhere you will find the principles of natural justice. You can also talk about the other articles like removal of the public servants 309, 311 etc. वहाँ भी natural justice has to be there. So these principles are certain principles which cannot be curtailed. They are found everywhere in the constitution. Undercurrents की तरह है. Now suppose this is a tub. एक tub है. This is, and in this it is a block of wood. One block. किसी भी चीज का एक block मान लो. एक brick मान लो, brick block. This is second block and this is third block. So block is what? Consider block as articles. Means this tub is a constitution and these blocks, different blocks are articles in this constitution. This is 21, 14, 19 and so forth. अब इसको ऊपर से देखें, it is equality and this is democracy, freedom of speech and expression all, and this is life and personal liberty. You talk about 25, that is religion, freedom of religion. So these are different fundamental rights, and manifestly they are related to different topics. Expressly they are related to different topics. But you see, within them there are certain principles which you will find that they are cutting across all these. अलग अलग प्रिंसिपल्स हैं जो कि आपको हर एक प्रोविजन में मिलेंगे, कटिंग अक्रॉस ऑल दीज। इस प्रकार से ब्लॉक को के ऊपर से वाटर इज फ्लोटिंग इन ए टब, सो दीज करेंट्स, वाटर करेंट्स आर कटिंग अक्रॉस ऑल दीज ब्लॉक्स। अब मान लीजिए वन करेंट इज डिनोटिंग द it is of natural justice, another current is of reasonableness, another thread is of equality. So there are various threads which are cutting across these, so and so forth. Suppose one thread is cutting of social and individual justice. Now you may not find these words used into the constitution in these articles in as many terms, but you will find that these various provisions of the constitution, they have got these principles as an undercurrent, as an implied principle, inherent principle or implicit principle, and they are cutting across all over there in provisions, these provisions. So ये जो thread हमने बनाए हैं, these currents are called overarching. So basically ये जो कहना चाह रहे हैं, these are not talking about some sets of isolated principles. They are not talking about some set of isolated doctrine. They are certain principles which are cutting across all the various provisions of the Constitution. That is the importance of, or you can say that is the overwhelming preference of, या फिर omnipresence of the elements of the बेसिक स्ट्रक्चर। तो ये यहाँ पर यही बताने की कोशिश कर रहे हैं कि बेसिक स्ट्रक्चर का एलिमेंट आपको किसी एक आर्टिकल में अकेला नहीं मिलेगा, वो कट अक्रॉस हो रहा है अलग अलग आर्टिकल्स के थ्रू, इट इज कटिंग अक्रॉस, एंड दैट इज व्हाट वी कॉल्ड इट ओवरआर्चिंग प्रिंसिपल। सो राइट डाउन, द कोर्ट हेल्ड दैट द वेरियस एलिमेंट्स ऑफ बेसिक स्ट्रक्चर आर सच प्रिंसिपल्स which cannot be seen in isolation, rather they have to be seen as being omnipresent, सार्वभौमिक, omnipresent in the constitution. Omnipresent means सार्वभौमिक, इस सब जगह व्याप्त है। Omnipresent in the constitution, and they cut across the various provisions of the constitution. For instance, for example, the principle of natural justice cannot be seen with respect to only Article 14, rather it is to be found in Article 19, 21, 25 and every other provisions of the Indian Constitution. And this the next point is, fourth point is, write down, the court gave the test of essence of right, that is whenever if fundamental right is amended. Court gave the test of essence of right. That is, whenever a fundamental right is amended and on the face of it, it appears that the said fundamental right has been restricted or abridged, the real test is not the express wording of the fundamental right, rather the real test is the essential principle implicit within that fundamental right, and it has to be examined as to whether the said principle has been violated और नॉट। अब इसमें इस केस में 16 आर्टिकल 16 4A और B पे क्या था, वो जब हम 16 आर्टिकल 16 पर आएंगे, there we would see. So in this case, M. Nagraj, the judgment delivered by S.H. Kapadia Justice. It is 5 judges bench. Now let's see the another case, that is I.R. COLEHO, dead by LRs versus State of Tamil Nadu. It is 9 judges bench, and the judgment is delivered by Y.K. Sabharwal, Justice. It is 2007 Supreme Court case. What is dead means? Dead means this person died during the proceedings and later on his LRs represented him in the proceedings. In this case, the constitutional validity of ninth schedule was involved as to whether the ninth schedule is constitutional or not. So basically, it is also related to the basic structure only. As we already know that in the Kesavanand Bharati case, Supreme Court already said that the basic structure of the constitution cannot be taken away or abridged. It cannot be violated. And उसके basis पर what they have the issue raised, जो issue raised हुआ था, it was that कि ninth schedule, whenever you are having a law in ninth schedule and you are putting it into the ninth schedule, whenever you amend the constitution to put the law into the ninth schedule, क्योंकि डायरेक्टली तो हम लॉ को डाल नहीं सकते नाइन्थ शेड्यूल में, एवरी टाइम यू हैव टू अमेंड द कॉन्स्टिट्यूशन एंड बेसिक स्ट्रक्चर का जो डॉक्ट्रिन है वो किसके ऊपर लगेगा? बेसिक स्ट्रक्चर का रूल विल अप्लाई अपॉन द अमेंडमेंट. और केशवनंद भारती का केस क्या कहता है? एनी अमेंडमेंट विच टेक्स अवे द बेसिक स्ट्रक्चर विच अफेक्ट्स द बेसिक स्ट्रक्चर एडवर्सली विल बी अनकॉन्स्टिट्यूशनल. तो ये तो कह रहा है हमारा केशवनंद भारती. एंड नाउ द पॉइंट इज कि नाइन्थ शेड्यूल में whenever you have added any law, you are amending the constitution through act. So can you add any such law which affects the basic structure? Can you add that law by the amendment in the ninth schedule? Will it not be unconstitutional? अब देखो जैसे आपने कोई लैंड रिफॉर्म एक्ट बनाया, प्रोग्रेसिव लॉ है, अच्छा लॉ है, आपने अमेंड किया और नाइन्थ शेड्यूल में डाल दिया. या फिर कोई एक रिजर्वेशन के लिए आपने लॉ बनाया और वो अमेंड किया, ऐड किया और नाइन्थ शेड्यूल में डाल दिया. लेकिन सपोज यू मेक ए नेगेटिव लॉ. नेगेटिव लॉ मीन्स विच इज यूजलेस, मीन्स इट डज नॉट फुलफिल द सोशल जस्टिस. फॉर एग्जाम्पल, मान लो किसी स्टेट में ओबीसी SC ST को 80%, 85% रिजर्वेशन दे दिया वोट बैंक के चक्कर में किसी स्टेट में, एंड द स्टेट गवर्नमेंट हैज नॉट गिवन एनी राइवल रीजंस टू द एक्सटेंट ऑफ बैकवर्डनेस एंड द नंबर ऑफ OBC SCs and STs is not as much so as to entitled to have a 80-85% of reservation, but the state make that law and the state is run by such political party which is of the coalition with the central government, and the central government knows अगर ये coalition support withdraw कर ले तो हमारी सरकार गिर जाएगी. और इस स्टेट गवर्नमेंट ने लॉ बनाया और सेंटर के पास भेज दिया कि आप इस लॉ को अमेंड करो, add it into the ninth schedule after the amendment so that it would be beyond the scope of the judicial review, and the law is bogus, vague. Why? Because it is not upon any survey report और कमेटी की इस तरीके से नहीं बनाया गया था. So it ultimately violates the requirement of social justice. But in our example, still the central want to survive its governance, and it could be possible with the support of the state government which is passing the law. So the central government get the bill passed और सेंट्रल गवर्नमेंट ने उस लॉ को अमेंडमेंट करके नाइन्थ शेड्यूल में डाल दिया. अब नाइन्थ शेड्यूल में यू आर एडिंग ए लॉ विच इज वायलेटिंग द रिक्वायरमेंट्स ऑफ सोशल जस्टिस बिकॉज इन दैट स्टेट इट इज ऑल नॉट जस्टिफाइड. अगर जस्टिफाइड है देन इट इज ओके, बट इधर हम मानकर चल रहे हैं दैट इट इज नॉट जस्टिफाइड. देयर इज नो क्वांटिटेटिव data, there is no survey, no report that such amount of reservation is required in that state. Because you know that इंदिरा साहनी जजमेंट में 50% रिजर्वेशन की बात की थी, लेकिन उसके बाद जो अदर जजमेंट्स लाइक द नागराज जजमेंट, उसमें कहा था कि हम 50% को भी एक्सीड कर सकते हैं एज पर द बैकवर्डनेस इन द state, depending upon the level of the backwardness of in that community, in that state. So in our example, 80% is not justified. So the requirements of social justice are violated. But you have put it into the ninth schedule and it go beyond the scope of the judicial review. So is not this particular amendment you have put into the ninth schedule, is it not affecting the basic structure? Is not this particular amendment which has put this law into the ninth schedule affecting the basic structure of constitution adversely? And here basic structure is what? Social justice we are talking about. So will this amendment by which the law has been put, can that be challenged and can that be declared unconstitutional on the basis of केशवनंद भारती जजमेंट? क्योंकि 9th शेड्यूल में जो आपने डाला है वो तो अमेंडमेंट करके डाला है. टेक्निकली द डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर अप्लाइज अपॉन अमेंडमेंट्स, and by amendment you have put a law beyond the scope of judicial review, and that law is actually violative of the requirements of social justice. So is it not affecting adversely the basic structure of the constitution? And since it is affecting the basic structure of the constitution, that amendment can be challenged. And if that amendment is challenged and found and declared to be unconstitutional, तो वो जो लॉ है अमेंडमेंट के थ्रू जो आपने 9th शेड्यूल में डाला था, क्योंकि वो अमेंडमेंट ही अनकॉन्स्टिट्यूशनल हो गया, तो वो लॉ है जो 9th शेड्यूल में है वो 9th शेड्यूल से बाहर हो जाएगा. और एक बार जब 9th शेड्यूल से वो लॉ बाहर हो जाएगा तो कॉन्स्टिट्यूशनल वायलेशन के ग्राउंड पर उस लॉ को आप अनकॉन्स्टिट्यूशनल डिक्लेयर कर दोगे. So the court held in this case that the 9th schedule is beyond the scope of judicial review. It would be fine. 9th शेड्यूल में एक बार लॉ चला गया तो उस लॉ को आप चैलेंज नहीं कर सकते, लेकिन अमेंडमेंट को तो आप चैलेंज कर ही सकते हो, क्योंकि अमेंडमेंट कैन बी चैलेंज्ड ऑन द ग्राउंड ऑफ द बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन, एंड वंस द अमेंडमेंट इज डिक्लेयर्ड टू बी अनकॉन्स्टिट्यूशनल, then the law is exposed. Means the cover of the 9th schedule is removed and the law comes out of the 9th schedule. And once the law comes out of the 9th schedule, then by the normal process, the Supreme Court can always declare that law be unconstitutional. And when this case came to the Supreme Court, there are several laws which are put into the 9th schedule. So a question also arose for the examination of each and every law. So for that question, the court held that we are not sitting here to examine each and every law which are in the 9th schedule since the Kesavanand Bharati judgment. But the court held that as and when the case comes before the court with respect to any particular amendment which put the law into the 9th schedule, then the court is always free to examine that particular amendment and declare that to be unconstitutional. So Supreme Court ने उस टाइम कहा कि जो एक बार में हम सारे के सारे लॉज जो 9th शेड्यूल में गए हैं उसको हम एक साथ तो एग्जामिन नहीं कर सकते हैं. वी आर नॉट ए रिव्यू कमिटी हियर, वी आर जुडिशियरी. But we certainly will hear the case if the particular amendment has been challenged, and the process will be challenge the amendment and we will examine the law. We will actually see that it is actually violating the law, and if it is found that it is actually violating, then that amendment will be declared unconstitutional and therefore the law is brought out of the 9th schedule. And once it is brought out of the 9th schedule, then on the basis of violating the constitution, the law can be declared to be unconstitutional. क्योंकि जैसे ही लॉ बाहर आएगा क्योंकि आपने चैलेंज किसको किया, लॉ को नहीं किया चैलेंज, आपने अमेंडमेंट को चैलेंज किया है बेसिक स्ट्रक्चर के बेसिस पर। अब वो अमेंडमेंट अनकॉन्स्टिट्यूशनल हो गया, तो लॉ तो बाहर आ गया। अब जब लॉ बाहर आ गया, देन इट इज नॉट बियॉन्ड द स्कोप ऑफ जुडिशियल रिव्यू नाउ इट इज हेड बाय जुडिशियल रिव्यू, एंड द कोर्ट कैन ऑलवेज review the constitution and take the law and declare it to be unconstitutional। और इसी केस में सुप्रीम कोर्ट ने एक और टेस्ट दिया था, जैसे एम नागराज में हमने पढ़ा है द एसेंस ऑफ राइट। तब इस केस में बेसिक स्ट्रक्चर समझाने के प्रोसेस में सुप्रीम कोर्ट ने यूज किया था वर्ड एसेंस ऑफ राइट्स, यहाँ पर एस लगा दिया। In Nagraj case, it is essence of right, and in this case, it is essence of rights. In Nagraj, it was single, and here it is plural. Nagraj में it is single right। जब भी एक लॉ राइट वायलेट होगा, तो उस राइट को देखो, उसके प्रिंसिपल को देखो। यहाँ पर ये कह रहे हैं कि अगर एक पर्टिकुलर आर्टिकल ऑफ द कॉन्स्टिट्यूशन इज अमेंडेड, तो आप सिर्फ उस आर्टिकल को नहीं देखोगे या सिर्फ उस आर्टिकल के प्रिंसिपल को नहीं देखोगे। सिंस देयर आर ओवरआर्चिंग प्रिंसिपल्स, दे आर कटिंग अक्रॉस ऑल द आर्टिकल्स ईच अदर, एंड इफ वी टेक आउट एनी ओवरआर्चिंग प्रिंसिपल फ्रॉम दैट, देन इट विल डिस्टर्ब ऑल द लॉक्स एंड दे विल गो अप एंड डाउन। जैसे हमने टब वाला एग्जाम्पल लिया था, इन दैट suppose there are threads cutting across in this and locks are tying with that, और अब इस thread को ये हम बाहर से खींचते हैं, then it will disturb all the locks, they will disturb and from their places because they are connected with this thread with each other। अब मान लो एक आर्टिकल को आपने अमेंड किया, इस ब्लॉक को अमेंड किया आपने, अब मान लीजिए उसका बेसिक प्रिंसिपल इज नॉट दैट मच अफेक्टेड, बट जो इसके जो प्रिंसिपल्स हैं, दीज आर कटिंग अक्रॉस वेरियस other articles in the constitution, so there are chances that the essential principle of that other article may be more affected, so you cannot, while examining the basic structure has been violated, you cannot go through for examining that particular article only or its essence or its essential principle. Rather, you have to take a comprehensive view of all the connected articles, and you have to see what is the effect of that amendment, on all these articles and their basic principles. And while examining, if you find that some of the principles of these articles are violated, then that amendment will be unconstitutional. So basically जो test of violation है उसको यहाँ पर और comprehensive बनाने की कोशिश की गई, इस केस में और comprehensive बनाने की कोशिश की गई है। इसलिए हम सिर्फ एक आर्टिकल के बेसिक प्रिंसिपल को चेक नहीं करेंगे, क्योंकि ये प्रिंसिपल्स सारे आर्टिकल्स के प्रिंसिपल्स को कट अक्रॉस करते हैं। तो आप सारे आर्टिकल्स में बेसिक जो फंडामेंटल राइट्स हैं, उन सारे फंडामेंटल राइट्स को देखोगे, कहीं किसी और आर्टिकल के प्रिंसिपल्स तो वायलेट नहीं हो रहे। फॉर एग्जाम्पल, अगर आप इक्विटी को वायलेट करते हो तो जरूरी नहीं है 14 ही वायलेट हो सकता है 21 भी वायलेट हो, बिकॉज इक्विटी cut across all these provisions. So they are suggesting that a more comprehensive view has to be taken, means a synoptic view. Synoptic means synopsis होता है ना, एक synoptic view of all the provisions of the constitutions, basic provisions of the constitution, synoptic view of all the important provisions of the constitution, such as DPSP, fundamental rights, whatever. You have to see the other articles and their principles, whether they are violated or not. So इस केस में जो S लगा दिया rights, so it means the essence of not only one right, it means the essence of all those rights, and in essence of all those rights are having the same principles cutting across. So Here we are talking about essence of rights in this case. But in NAGRAJ we have talked about essence of right. S is not there. So write down regarding the scope of judicial review of a law put in the 9th schedule, the court held that any law, if put in the 9th schedule, will go beyond the limitation of judicial review. It cannot be challenged. Go beyond the limitation of judicial review. As per Article 13B, 13 Clause B, 31B. It will go beyond the limitation of judicial review as per Article 31B. It is not 13, 31B. However, the amendment by which that law was put in 9th schedule can always be challenged on the ground of violation of basic structure, and once the amendment is found to be unconstitutional, the amendment will be declared void or ultra vires, and thus the law which was inserted in 9th schedule would be brought out of 9th schedule, and now it can always be subjected to judicial review and be declared to void on the ground of being violated of Constitution. On the ground of being violated of the Constitution. However, the court also held that all such amendments cannot be examined in one go. Rather, individually they can be challenged before Supreme Court, and the court can one by one, as and when challenged, declare them to be unconstitutional. Now write down the next point. Regarding the test for basic structure, the court gave the test for essence of rights. It held that in order to examine whether the basic structure violated or not, the court should not only look at the essence of that particular right, rather it has to take a synoptic view of all the fundamental rights in their essence, and then it has to examine whether any of these essential principles is being violated or not. So सभी फंडामेंटल राइट्स को आप एक साथ देखोगे और फिर आप देखोगे वो जो प्रिंसिपल है जो कट अक्रॉस करता है सबको, वो वायलेट हो रहा है कि नहीं। एक को देखकर शायद आपको ना पता चले, क्योंकि हो सकता है एक का एसेंस वायलेट होता हुआ नहीं दिख रहा हो, लेकिन हो सकता है दूसरे का एसेंस और क्लियरली वायलेट होता हुआ दिखे। सो इट इज बेटर टू एग्जामिन all the important fundamental rights and then to decide whether the basic structure is violated or not. So that is where one more concept comes out. अगर आपसे पूछा जाए कि are the fundamental rights mutually exclusive, तो generally you will say no, but अगर initially हम initial judgments को देखें, जैसे A.K. गोपालन judgment and the Khadak Singh judgment, the Supreme Court held. These judgments are not very important for our purpose, but as passing reference, you should know that the Supreme Court held that the fundamental rights are mutually exclusive. खास करके A.K. गोपालन में ये कहा गया था. It was in 1950 Supreme Court, and the Supreme Court in this held that the fundamental rights are to be examined in isolation. लेकिन मेनका गांधी जजमेंट के बाद ये क्लियर हो गया था that the fundamental rights are not mutually exclusive. अब सवाल ये उठता है क्यों एक्सक्लूसिव नहीं है? क्या एक फंडामेंटल राइट को एग्जामिन करोगे दूसरे को टच नहीं कर सकते? पहले जो जजमेंट थे ये गोपालन वाले उसमें था कि नहीं कर सकते, बट अब जो बाद वाले जजमेंट से इसमें इसके हिसाब से है, एक नहीं, आप सबको देखो। सो वी आर टॉकिंग अबाउट हियर इज सिनॉप्टिक व्यू एंड अंडर करंट ओवरआर्चिंग प्रिंसिपल्स, जो हम ये बात कर रहे हैं। सो एक्चुअली दिस इज दे कनेक्ट्स फंडामेंटल राइट, एक यहाँ पर है, एक यहाँ पर है, एक यहाँ पर है, एंड इन सब के अंदर these principles, in सब के अंदर these principles are there and they are connecting them. So how can the fundamental rights be mutually exclusive? Because they are all connected with each other because of these overarching principles. So basic structure doctrine की वजह से now we also understand that the fundamental rights cannot be seen in isolations with each other, and this is very important understanding. ये जो अभी हम डिस्कस कर रहे हैं, this is the very important realization of the constitution. So हम जो भी टॉपिक पढ़ रहे हैं, तो उधर we are connecting each and every topic of the constitution with the social justice, equity. Why? Because these are the connecting principles. So there are various connecting principles in the Indian constitution which are cutting across overarching the articles. So you always realize this, जब अगर 14 की बात कर रहे हैं तो 21 का रेफरेंस अपने आप आएगा, because these are connected through underlying principles, and those underlying principles are the basic structure, and therefore the constitution cannot be seen as a document having certain articles isolation with each other and having normal statutes and one article interpreted and then we go to other article to interpret and there are no linking between them. So the constitution is very comprehensive document. So there are several threads which are attached with different articles, खास करके essence of constitution की बात करो तो, and उसी के ऊपर you will find these articles, but these are all connected with each other through threads, and these threads only give the comprehensive character to the constitution. So we cannot see the constitution in the parts of isolated topics. सबका प्लेसमेंट तो अलग अलग हो सकता है। फंडामेंटल राइट्स आपको पार्ट 3 में मिल जाएगा, डीपीएसपी आपको पार्ट 4 में मिल जाएगा, फंडामेंटल ड्यूटीज आपको पार्ट 4A में मिल जाएगा, लेकिन सबका अंडरलाइन करंट है जो वही है। ड्यूटीज का कॉन्टेक्स्ट थोड़ा सा डिफरेंट होगा। अगर मेरे पास राइट है तो मेरे ऊपर ड्यूटी भी है कि मैं ऐसा करूं। डीपीएसपी अगर मेरे पास राइट है तो मेरे पास एक और पॉजिटिव राइट है कि स्टेट ऐसा करे जिससे मेरा फंडामेंटल राइट इफेक्टिवली इम्प्लीमेंट हो, लेकिन मैं उसको इम्पोज नहीं कर सकता, लेकिन उसके बिना फंडामेंटल राइट भी यूजलेस हो जाएंगे। सो एवरी इंडिविजुअल हैविंग द राइट्स, दैट इज फंडामेंटल राइट्स, एंड एवरी इंडिविजुअल हैविंग द लार्जर राइट्स, दैट इज डीपीएसपी, and every individual also have a duty, because without duty there cannot be an organized movement of the society. So these all these three are complementing each other. अब ये बात हम कैसे समझते हैं कि क्योंकि इन तीनों को वो जो लार्जर पर्पस है या जो लार्जर प्रिंसिपल है वो बाइंड कर रहा है. So that is what there is in the constitution, which is realized after Manka Gandhi judgment, and in M. Nagraj may be that there are certain principles and these principles cannot be seen in isolation, and these principles are intertwined. मतलब एक दूसरे में गुथे हुए, क्योंकि हम इस तरीके से भी देख सकते हैं कि ये ओवरआर्चिंग प्रिंसिपल्स है, ये इक्वलिटी है, सोशल जस्टिस है एंड रीजनेबलनेस है, तो एक दूसरे के पैरेलल हैं ये. तो दीज आर नॉट पैरेलल्स, दे आर इंटरट्विन्ड, एक दूसरे के ऊपर, लाइक दिस इंटरट्विन्ड. These principles are from one upon other. So that is what called intertwined. मतलब they are not only found under the current, but they are engaged from one another. एक दूसरे से engaged हैं. अगर एक को खींचोगे तो दूसरा इफेक्ट अपने आप ऑटोमेटिकली हो जाएगा. And that is what adds life to the constitution. For example, we take social justice. If we talk about the social justice, it is not only about the social justice, it is equity based social justice. It is about reasonableness. अगर reasonableness ना हो तो social justice achieve नहीं हो सकता. And that is what they are intertwined with each other, and they are living under current. In some they are more manifest and some they are less manifest, but these principles has to be there. For example, हम secularism की बात कर लें, that is freedom of religion. If freedom of religion of certain religion, if किसी particular religion का is curtailed in India, then now it is not also the violation of equality, because Article 14 says that there has to be equal treatment of an individual or a group. Suppose a Muslim and a Muslim group. So the Muslim is having a right to equality. A single Muslim person is having a right to equality as an individual. Plus, when we are talking about of a Muslim group, the entire community of Muslim group is also having right to equality in the matters of religion. Similarly, suppose Hindus are given freedom of religion, and suppose, for example, Muslims are not given as much freedom as Hindus are given, or Jews or Parsis or Christian, any community is not giving as much as freedom the other community is given. So, in this situation, is it not the violation of right to equality of that particular religion? The answer is yes. Since it is a matter of religion, and in that matter they are having a right to equality, so it is basically a violation of secularism. It is a violation of secularism, so the equality also get affected. And धार्मिक जो अनुसरण करते हैं कोई व्यक्ति या ग्रुप ऑफ persons, this is also a social process. And if you are not doing justice and following of that particular religion, then you ultimately do social injustice to that group or that individual. So that is a small example. There are several kinds of examples, and there are several overarching principles, not only these, which are intertwined and binding each other. So what I mean to say is that secularism को आप सिर्फ secularism के दायरे में रहकर नहीं देख सकते. You have to look at it in the larger perspective, on the point of justice, equity, social justice, and so forth. So it is to be remember कि ये सारी चीजें आपको बतानी पड़ेगी. ध्यान रखना, एग्जाम में अगर इतना नहीं लिखोगे आपको अच्छे मार्क्स नहीं मिलेंगे. जैसे कोई लिख कर आ गया, बेसिक स्ट्रक्चर इज अ सेट ऑफ सर्टेन प्रिंसिपल्स विच आर इनवायलेबल. ये भी सही है, ऐसा नहीं है, गलत है सारी चीज. बट अगर मेंस में क्वेश्चन पूछा है या इंटरव्यू में आपसे पूछा है, देन देयर यू मस्ट टेल देम व्हाट यू हैव अंडरस्टूड. इट इज नॉट व्हाट यू हैव टेकन इट फ्रॉम द बुक्स, बट you have to tell them what you have understood. You must tell them essentially the basic structure is the set of principles, and the principles are derived from the Indian society. So these are the societal principles which have been made the bedrock of the foundation of the Indian Constitution. And you must also tell them that they are not expressly written in the Indian Constitution. Then you must essentially tell them that these principles constitute the identity of the Indian Constitution. तो उसी प्रकार से अगर इंटरव्यू में आपसे पूछा जाए तो एग्जाम्पल सेटअप करके आप बता सकते हैं, विद ड्यू रेस्पेक्ट ऑफ द कमिटी, आई वांट टू गिव विद एन एग्जाम्पल, आई वांट टू अंडरस्टैंड. अगर वो कहते हैं यस गिव एन एग्जाम्पल, तो उसको कह सकते हो, सपोज द कमिटी इज सिटिंग हियर और द पर्सन सिटिंग इन दिस रूम, यू आर हैविंग द certain set of principles which above which you cannot overcome, you can modify in a better way. You are having certain principles in your life, certain, and in daily wears we are changing our clothes, in party wears and home at sleeping time, etc. That is not our identity. So इस तरीके से अगर आप समझाओगे, then they would give you the full marks. So उसी में आप overarching के principles के बारे में बता दोगे. So you will tell them that it is implicit in case of non-Bharati case only, but very explicitly it is written in M. Nagraj judgment, M. Nagraj versus Union of India. Judge का भी नाम याद रख लो, S.H. Kapadia Justice, and tell them that this explain the real character of these principles, and they have explained that these principles has not to be seen in isolation. They are cutting across all the provisions, intertwined each other, and if we one of them is touched upon, if we touched upon one of them, then others also get affected. Though apparently one of them article of one of the provisions is get to be seen affected, but if we see in deeply, if we go into the examination, the other elements also do get distorted and affected. So the essential characteristic or important characteristic of basic structure. So basic structure के principles को आप अलग अलग नहीं देख सकते, वो सब आपस में मिले हुए हैं. एक को खींचेंगे, बाकी सब भी affected होंगे. So that is all about the basic structure and its concept. And that's it for this lecture, and thank you for watching this lecture.